estate planning. Estate planning has to take into account, at least in my mind, good estate planning has to take into account your financial plan. Needs to take into account all your investments. It needs to take into account what your need for retirement, what you're doing for insurance, tax planning, and the younger you are, the more critical it becomes that you are paying attention to preserving what you have and having it grow. So, and we have a big chunk of the middle class, especially the baby boomers, who still have big mortgages. That all of their money is in retirement plan accounts, and they've never sat down and figured out what it's going to take on an ongoing basis. I talk about developing a spending plan to actually live the way they want. And one of the downsides of doing that is sometimes you figure out that your plan may be to die pretty soon, because the money's going to run out way quicker than you think, or you're going to have to work a lot longer. Well, there are a lot of ways of solving the problem, you know. So the estate planning side is really, I think, primarily about making sure that you stay in control as long as you can, as long as you want to. Sometimes want to and can are different, okay? Preserving and protecting what you have. We're going to talk about that some more. Most of the middle class does a terrible job of preserving and protecting what they have, because nobody's talking about how to do it, or even that it's an important issue. Tax planning, there are becoming fewer and fewer opportunities to do any real income tax planning. The new tax act, if you make a lot of income, if you have the opportunity to have multiple businesses, then there's a lot of tax planning that can be done there. We do work with folks with those kind of incomes and situations, but the vast majority of people, there's just really not a lot left that can be done for income tax planning. And estate tax planning, most of the existing estate planning that we see people having been done was driven by estate tax concerns. And for married couples, most of that planning is going to produce a much worse outcome because of income taxes that were not considered in the original plan. Maybe I'll come back and address this a little more deeply. When your focus on planning is about avoiding estate taxes, then the way most of those plans are structured, we're going to pay avoidable income taxes at the second death. You have to think a little differently and longer about how you arrange things. So this comes back to, say, your estate plan ties into financial plan. How many of you think it's a good idea to have your money run out before you do? No, nobody signed up for that plan? Okay? So it's critical that you have figured out how to try and make sure that the resources you have today are going to last for the rest of your life. How long is the rest of your life going to be?
I don't know.
Don't know. what kind of health crises are you gonna have along the way? Because I know by the time you get to retirement age, one of the biggest risks that you have in front of you are healthcare costs. And I'm not talking just long-term care. Long-term care in addition, on top of that. Because they've done a tremendous job of extending life expectancy, but they have not extended healthy life expectancy. I saw a study recently that says that the average American will be suffering from and dealing with chronic and debilitating diseases the last 13 years of their life. I don't see that exciting anybody. So you have to have a really good picture of where you are and where you want to be. You also want to arrange your affairs so you minimize loss of what you have. And again, that loss comes from a lot of different ways. Okay? It can be from lawsuits, it can be from divorces, it can be from errors in judgment. There needs to be a plan in terms of how to pay for care. We've been talking about some of these different things. I've been doing this around it long enough. I remember when nursing home was under $25 a day. Okay? That was hundreds of dollars a day. So you have to figure out how to do that. One of the things that we also have to be concerned about in our practice is making sure that we're really hearing the parents' wishes, not somebody else's. Anytime I have a child who is really upset, when I invite them to spend some time in the lobby, I usually know I got a problem. Okay. The last point there on that slide is about legacy. If in fact we can help you get through your life in a manner that you find comfortable and desirable, then if we can do that and have your affairs arranged in a manner such that there's something left, how do you want to leave it? Have you thought about it? See, well, here's what we know about inherited wealth. Well, first, how many of you would think it's a good idea to give an 18-year-old 50 grand in cash? We don't have any 18-year-olds in the audience, okay? Nobody thinks that's a good idea. But the American Bankers Association did a study a number of years ago, and what they concluded from that study was actual inheritances. They found that in about half of them are gone in about a year. And 80%'s gone in 3 years. Now, here, and they say, wow. And probably people are not shocked that inherited money goes away that quickly. But what they found is it really didn't matter how old the beneficiaries were. See, because what we know is it takes time to create a relationship with money. If you have earned it, you created it yourself, it's accreted over time, you treat it entirely differently than money that just shows up. And if every one of you take and think about your life, when you had a windfall, you got money that came in you weren't expecting, wasn't there something that you would just knew you absolutely needed to get it done because now you could? And everybody had that opportunity, right? Yeah, right. Okay? And so there are books written on this, one of which is Sudden Wealth, that talks not only about the fact that it frequently gets dissipated, but the impact that it has on relationships and whatever with people. So the more that you can get your head around the impact that you want to make in the future, the more likely we can do planning that will help that impact happen. and actually dropping money in the hot little hands of the beneficiaries directly may be bad for them. Okay, now the heading of this slide is useful tools. IRAs, 401ks, 403bs, they are to do really good planning for. They are some of the most difficult assets to plan for, because anything you do with them currently generates income tax, right? Okay. When they pass to a child or other beneficiary, that money comes out and is taxable to them. So that $100,000 IRA really isn't worth $100,000, which kind of goes back to your question earlier. I know it's really not that much, okay? It's something less. But here's another, and this was somebody I was having dinner with the other night. He was talking about he was not going to take any money out of his IRAs to pay a creditor. Why wouldn't he do that? Because he's going to have to pay taxes on it. Okay? And so if you take $1 to pay a creditor, you got to take, depending on tax bracket and how much, you may have to take $1.50, $1.60 to be able to pay the dollar, because you take the dollar out, now you got to take out more money to get it back to $1 because you had to pay tax on it. But because you took the taxes out, you got to take more money out to pay the taxes on the money you took to pay the taxes. But you have to take more money out to pay the taxes on the money that you took out to pay the taxes on the taxes that you paid on the money that you took. It's called an iteration. Okay? And see, now in his circumstance, he was just being cranky because cash flow is not really great right now. He's got plenty of time, but he knows something that maybe many of you don't. No creditor can make you take money out of your IRA, 401k, profit sharing plan, whatever. They can't make you take it. Supreme Court's been really clear about that. Statute here in Connecticut's really clear about that. But as quick as you, and so these are useful tools for creating wealth to help have money for the rest of your life. But when it comes passing it on to the kids, while it's protected for you when you pass it on to the kids, Supreme Court says their divorcing spouse, any of their creditors, a bankruptcy trustee, they can all take it away from them. The law says you can do planning to protect that. Okay. But then we have to make sure that we do it in an income tax efficient way. Okay. Long-term care insurance, as I said earlier when we talked about long-term care insurance, I think everybody should take a look at it and think about it, figure out is it a viable tool for them, but you need to look at least all three ways. Traditional long-term care insurance, life insurance contracts where you can turn the death benefit into long-term care, and annuities where you can get some leverage, tax-free leverage off the funds in the annuity. Somebody asked me if they had existing annuities, could they qualify them? No, and that's not exactly the question, but basically part of the 2006 Pension Protection Act, which just became effective in 2010, said if you have an annuity and you build up a lot of cash in it, you can transfer it over into one of these long-term care insurance annuities, and you can do that tax-free, and then that annuity will furnish you anywhere from 2 to 4 times as much in dollars to help pay for long-term care. And they're easier to qualify for than traditional long-term care. We already talked about the irrevocable burial reserve zone. So, what happens to your estate when you die? Okay. Because several people who asked questions, I said, I'm going to talk about this estate stuff before I get done today. Okay? what happens when you die? Well, let me ask a different question. How many of you want to avoid probate? If I hold my hand up long enough, you'll all go along? Here's what I'm going to tell you. Probate is really, really easy to avoid. You do not need an attorney to avoid probate. I know that there are literally thousands, probably tens of thousands of people in Connecticut who have bought a trust because they wanted to avoid probate. You don't need a trust to avoid probate. Okay? Because you see over here, it says contracts, joint beneficiary beneficiary designations, transfer on death, in trust for transfer on death, all avoid probate. And this, I'm not really going to get into what probate really is about. We'll talk about it some more. But the avoidance of probate should not be the principal driver for how you choose to arrange your estate plan. Okay? And it has been for way too many people. Because ultimately you're interested in terms of what gets to the heirs, right? And how it gets to them. Let me ask another question. I assume most of you either are married or have kids, or both, okay? So of everything that you leave either to your spouse or your children, if you skip the spouse or don't have one, how much of what you leave them do you want taken away from them because of a lawsuit, or bankruptcy, or a divorce? How much?
Yeah.
None? Half of it? No, not, so half's the right number, okay? So in my mind, it is far more important to address that desired outcome than it is to worry about probate. Because, and it's not that I think you need to use probate. It's just don't be afraid of it. Because I'm going to tell you in a minute, while married couples may want to use probate, at least for part of their affairs. Okay? So that's basically what happens, but how do we get there? First off, how many of you who want, of all those who wanted to avoid probate, how many of you have a will? Most of you. Oh, great. Okay, you don't love this. A will guarantees probate. Okay?
Can we tear it up? Act like it don't exist?
No, but what did I tell you about probate? Don't be afraid of it. Okay?
I can get rid of it.
Okay? Yeah, you got a shredder, you can get rid of it. Okay? Okay, here's the thing. A will means nothing while you're alive. Doesn't mean anything. Will becomes meaningful when we find after you die, we find the original and we submit it to the probate court. The judge looks at the will and the judge is going to determine, is it a valid will? At least does he believe it's valid. Okay? In Connecticut, we're then going to send out invitations to everybody who might have an interest in your affairs, and it's more people than you think, okay, to come in and express their opinion about is it valid and who should be named executor, okay? You can use a revocable trust, okay? And you can use an irrevocable trust, or you can use a special needs trust, which is just another irrevocable trust. Now, is everybody here familiar with trusts?
No.
No? Some degree. Some degree? Okay. Well, Larry, you want to come up and give the lecture on trust? Okay. I find almost everybody knows the word, okay? And I find that trusts are really not very well understood in that, well, everybody here is, I bet, qualifies here. Either you've been a babysitter, have hired a babysitter, or knows somebody who did one of those two things. Does that cover everybody? Anybody that doesn't fit? Okay, so we got some common ground here. Now, in the babysitter context, we have our parents who choose somebody they have faith and confidence in, they trust their judgment. They don't think so much about the fact that they're turning over the house and the furniture and maybe lunch money and whatever, okay, to the babysitter. And they're doing this all for the benefit of the child or children. And if you're gone for any length of time, okay, Janet, I don't know if you have kids or not, okay, if you're going to be gone for a week or two, are you likely to write some instructions about who, what, how, when, where, why, right? Okay? So all comfortable with that? Now, you now have finished the first semester in trust. Okay? And you say, well, hold it. I thought they were more complicated. No, no, no. You just have to learn new words. That's the second half. In the trust world, the parents would be called grantors, censors, trustors, or trust makers. That's the person who created the trust. The babysitter, that person whose judgment we trust, that's our trustee. The house and the furniture and whatever, that's the trust corpus or principal, assets. Okay? They all mean kind of the same thing. And the child or children, that is our beneficiary. Okay? And that set of the who, what, how, when, where, and what, that's our trust document. And so what's critically important is that we get your instructions in your trust, the names of trust, special needs trusts, those are almost always irrevocable. And all it says is, hey, we've got somebody who has some issues that we're probably trying to protect the money so we get qualified for some benefits. Okay? So it focuses on a function or a specific aspect of what we're trying to do with the trust. That's all the names mean. Okay? They don't tell you what the trust says, actually. So a big deal with estate planning, especially with seniors, is undue influence. Yes?
The revocable and the irrevocable trust, do they have to go to probate court?
No.
They don't.
No.
We'll come to you.
I just can't get you off that probate stuff. Okay?
We'll come to you, right?
The trust. The trust will have instructions about what happens, just as a contract will, or joint ownership will, or transfer on death will. There's still things that have to be done when somebody dies. So I'm not really getting into the estate settlement process. I'll get there in a minute. Actually, it'll be several minutes, but we're going to come back and explain that. But remember, you get to ask questions just before break.
Okay.
Okay?
Okay.
So undue influence is when somebody who has a confidential relationship with the person creating the plan, such that it is likely that that person who's creating the plan is going to fall under the influence that is improper influence in how they arrange their plans. It's, for instance, you have 3 kids. One spends a lot of time with mom. The others are in different parts of the country. And mom decides to leave everything to the child that's closest. Is that a product of undue influence or not? Don't know. But it's very important that we examine all the parameters of that relationship and what's going on. Has mom had a bad relationship with these other children? I mean, what was her plan like before this plan? Okay? There's a lot of things to look at, because undue influence simply means that the relationship's too close and the relationship is being used for the benefit of the influencer in almost all cases, okay? And the older we get, and the more dependent we become on our relationships with fewer and fewer people, the greater likelihood is we're going to end up with a plan that is somebody else's other than the true testator, the true deceiver, okay? So, and this part of it becomes a challenge, and that's why we always spend some time examining the relationships in the family, especially when we're treating people really very differently. The older the client, and it's not fair to use age as a primary criteria, but this is where most of it happens, okay, is the older clients. You gotta do good planning. You have to know about the family. If you have somebody who's trying to close out, you know, they want to be involved in conversations with mom, they want to know what's going on and whatever, and they're trying to close other people out, that's almost always a hallmark of where you've got undue influence going on, okay? Or at least somebody is trying to get there, okay? And we use irrevocable trusts a lot, and we try and use trustees that we have high confidence are going to be independent and aren't going to abuse the relationship. Okay, we'll talk about those some a little bit more, how we use some of those. Okay, so, I think I actually may be a little ahead of time here. So there have been several questions that I put off until this auspicious period. Now are they all gone? No questions? Yes.
I know you did the babysitter analogy and I sort of got it, but I really don't understand why, like, everybody wouldn't do a trust. Like, there's got to be some reasons. Like, is there like a downside?
Well, the downsides. Well, because they're not what everybody does, that's a downside, okay? They're largely misunderstood, misused, and misapplied. I shouldn't say large, there's a whole lot of that, okay? There's tons of people who have trusts that I don't understand them as well as you do after that little explanation I gave you, okay? Depending upon what we're trying to do with the trust. In fact, I'm going to talk more about trusts on the other side, irrevocable, what have you. It is my opinion, most people, if they have accumulated anything, and I'm not talking big, wealthy, they got a house, you know, they have enough money that it's going to help support them in retirement, should think about using a trust. Primarily to manage their affairs when they're incapacitated, not just to avoid probate. Okay, because if all you want to do is avoid probate, you don't, that's not, okay, you want to create the tool that helps you get the result you want.
Is it protected from that spend down?
Well, if we use an irrevocable trust, yes, and I've got a lot more to talk about on that, okay? And so this is, okay, I mentioned them, I didn't get into them, okay? Yes, Larry?
But a will, if it goes to probate, one, it costs money. You know.
It all costs money, Larry.
Yeah.
It does cost money. And secondly, it takes at least 6 months.
Well,
So that's why I'm going into trust.
well, if you use a trust, it still costs money, and there's still things that have to be done, and if you don't do them, it causes problems. Okay? So trust, see, and I don't mean to pick on you, Larry, you asked the question, okay? There is no such thing as a document that automatically takes care of settling it itself. It doesn't exist, okay? You're going to pay to the probate court, and probate court fees in Connecticut, this is not true in every state, but in Connecticut, you're going to pay the same money to the probate court, whether you have a revocable trust, because I'm sure that's what you're thinking about, the same money, if you've got a revocable trust, as whether you use a will, okay? And yes, you can probably get it done a little more quickly. But most importantly, you want to make sure you get the results for the people you care about. See, there's no reason to have a will or to have a trust unless there are people that you love and care for that are likely to be here after you. Because if you don't, if there isn't, why would you bother? Okay? The revocable trust, I will tell you, I do believe it is a better way to manage your affairs if you're incapacitated. Okay? But that has, okay, so, but it costs money to settle estates. It costs money to settle trusts. Some of the best work we get paid for, Larry, is cleaning up revocable trusts that weren't dealt with properly when the trust maker died. Okay? So, so to your question, why, if you understand them and you're comfortable with them, people do them. Okay? And they have since, you know, a fellow by the name of Norman Dacey wrote a book in 1969. I can't remember the title of it, but it was about why everybody should have a living trust. He was wrong about a lot of things. Okay? He was attacking the Connecticut probate system, actually. It became a national big deal. There are reasons why you don't use trusts, okay? And why you use a testamentary trust as opposed to a living trust. I want to talk more about this on the other side of our break. But what other questions do we have? Yes?
Is it true that one of the problems with trust is that a lot of times they're either completely unfunded or very much underfunded? The people don't do step 2 and move property into the trust once it's created.
The biggest problem with all estate planning is the assets are not aligned with the plan. And that, so I'm using aligned instead of funded, because this is true with will-based plans as well as with trust-based plans. Okay? And so, if you, I've said earlier, if you just want documents, go to LegalZoom. Trust me, LegalZoom doesn't care whether you align anything. Okay? They're not going to help you understand what should go where and why. Yeah? Another question. Is that it? We started talking a little bit about trust. I got a couple, 3 questions. I'll try and get to them in a minute. I want to talk a little bit more about. I didn't really say much about a revocable trust because sometimes I think it's obvious, but other times it's not. A revocable trust is a trust that you can revoke, modify, amend, put stuff in, take stuff out. You are typically not only the person who created it, but you're also the trustee, and you're the beneficiary. And that's why it's such a great tool to manage your affairs when you're incapacitated. Okay? But when we're trying to do planning for the VA or for Medicaid, then we tend to use irrevocable trust because since a revocable trust is your alter ego, a revocable trust does us absolutely no good when it comes to making assets non-countable for the VA, non-countable for Medicaid. We have to use irrevocable trust. Well, we don't have to, but it is a much better approach than just giving stuff to the kids. Okay? And we have any kids here? I know we got some kids here, right? So, I always tell parents, never give your kids anything. I even do it in the presence of the kids. Have I now alienated all of you? Okay?
I'm on your side.
Have you? I got one on my side, okay? 2, 3, okay?
That's right.
Here's what we see happens all the time. And this is in part a byproduct of 2 things. 1, wanting to protect stuff. And 2, wanting the lowest possible price. without considering the cost. Have you all either had family members or friends or neighbors or whatever that they've given the house to the kids? Any of you have that? You're familiar. And so they give the house to the kids because why?
Keep from paying taxes.
They want to protect it, okay? And they do one of those quick claim deeds that we talked about earlier. They, for $1, they sell the house to the kid, right? And we establish that that's really a gift, right?
Yes.
Okay, so let's apply some facts to this. We got mom and dad. We've got a house they paid $50 for. It's worth $250 now. Okay? We got 3 kids that we're giving it to. So if mom and dad have given the house to the kids and then they want to sell it to downsize, who has to do the selling? The kids. Okay. Now, is this house, well, the kids are going to agree, right? There's never a problem getting the kids to agree, right? So we're going to skip right over that little hurdle because they're good kids, they're going to go along. So we say, okay, we're going to sell the house. What's the difference between, if you subtract 50 from 250, what's the result? 200. And if the 50 is what you paid for something and 250 is what you sold it for, the difference is gain, right? And you have to pay tax on the gain? Yeah, you do if it's not your personal residence, and this is not the kid's personal residence, is it? No, of course not. So what's the tax on a $200,000 gain? It'd be $40,000 or more. Okay, now, here, so what did it cost to sell the house? What did it cost to sell the house? $40,000 or more, right? What was the price of doing the quitclaim deed? Probably under $400, all in, fees and everything. So which would you rather pay? $40,000 or $5,000? Now which would you rather pay? $40,000 or $5,000? $5. Or and you might even be willing to pay 10 instead of paying 40, right? Because it's pretty easy. When I just give you numbers, you can say, I want to pay the smaller number, okay? So I'll come back and revisit this again in a little bit. But so we don't sell the house. And what happens if one of those kids files bankruptcy? The bankruptcy trustee, they don't take a piece of the house, they force the sale of the house. So we're going to spend 10 or 15%, maybe 20% of the house on the sales costs, bankruptcy, without letting too much. And, oh, and now we still got to pay that tax, don't we? And what if one of those kids gets divorced? What's one of the assets likely to be taken into account in a marital settlement? On the house. The third kid gets sued and loses, what happens to the house? Okay? But the price for this document was really good, wasn't it? Okay? See, there's way too much focus on price without near enough thought about the consequences of what you get for the price you pay. Okay? Oh, let me add another little story. The folks live in the house, none of the bad things happen. The folks ultimately die, the kids now own the house. Okay? What are the kids going to do with the house? Well, guess what? We got that tax problem again. And with planning that would cost a lot more than $400, all of that could have been avoided, and the house could have been protected as well. Okay? So, and we do that with irrevocable trust. Is we can manage income tax results, we can manage estate tax results, and in most cases, in most families, we can arrange the assets so that they're protected from all the bad things that happen to good people. Okay? And that's why we use irrevocable trusts. They're one of the most powerful planning tools we have. Okay? And we use them for doing VA planning, we use them for doing Medicaid planning. Okay. So in most of what most people know about irrevocable trusts is driven by over 100 years of estate tax law. And what we do, how we use trusts is, in many cases, we're turning the rules on their head to use the rules against the IRS. So there's a huge opportunity to do a lot of meaningful planning using these specially designed trusts. Because what our focus is more about asset protection than it is on, well, there's virtually never any estate tax considerations. The reason I say that, the federal government says unless you have about more than $11.2 million, there's no estate tax to worry about. And certainly some folks have that. Married couples can have about 22 million, and they've only got to do a lot of people planning to avoid the tax there. The state of Connecticut says so long as you have 2.6 million or less, there's no estate tax issues. Okay? The married couple can have about 5.2 with a little bit of planning. Now certainly we do estate tax planning for people when it's called for, but oftentimes we see people who've done estate tax planning and they really should be doing income tax planning as part of their estate plan, not estate tax plan. Because the world has changed so much. See, what I know statistically, something less than 1/10 of 1% of the population has a federal estate tax problem. And at the state level, this year, it's 98% of the people don't have a problem. Okay? So what we're trying to do is figure out how to help people accomplish their objectives. Spend a fair amount, actually a lot of time on education to try and help them understand that. Somebody came up and said, I have people who don't want to do any of this trust planning because they think it's unethical. And I think really they were talking about planning to arrange to qualify for Medicaid 5 years later. Did I get that right? Okay? Because they think that's unethical. Do you think it's unethical for a Fortune 500 company to come to a town and negotiate a 10-year tax abatement? Is that unethical?
Yep.
Is it unethical for Exxon to get over $4 billion in tax savings because of the laws they helped negotiate to benefit them? Is that okay? Okay? So, do you know how much planning we have to do for the middle class to begin to catch up with what even one big company's done for themselves? I can't contemplate how much we would have to do for average middle class folks, right? Because it's not unethical. Well, I don't think it's unethical to use the rules that have been created by Congress and the state legislatures and the regulatory agencies to do what is best for our families, best for ourselves, and I believe in the long run, best for the largest share of the community. I wasn't going to talk about this, and it's certainly not part of the agenda. See,
Go ahead.
I could retire. I'm actually old enough. I know you think I'm only 27.
Yeah.
Okay?
Yep.
Okay. One of the reasons I keep doing this is I have really, really wealthy clients that I really like. They're great people. I can't make as much difference for their families in the long term as I can for your families. Okay? See, because I've been working since I was 10 years old. And I mean, actually, I went to work in a factory at 10. Okay? And I was making a good living at 16 working in the sawmill while I was still going to high school. Who today can make a good living that you can support a spouse who stays at home and have 3 or 4 kids running around with less than a high school education? It's not possible. The only way that you have an opportunity to make not a great living, but to be able to make something beyond working poor, is you have to go to college. You have to get this ticket that says, I'm willing to work in the system, and I'm smart enough to get through this institution. What does it cost to go to college today? My son's telling me that for my granddaughter, who will be 15 this summer, that he figures even in even going to a public institution, it's going to be well over $100,000 to get her through college. I interview people for jobs, and they've got $50, $75, $100, $150,000 in loans to get a bachelor's degree. And I've been doing so well. Right? To get a bachelor's degree. I interview young attorneys who have $150,000, $200,000, $300,000. I've got a doctor client who had over $500,000 in student loans. What's happened in the economy we have a political structure that has, since the late 70s, maybe earlier, has forced tremendous amounts of wealth up into fewer and fewer people. You know, those of you who are readers have heard of the Great Gatsby, and if you read, you know about the 1880s and the early 20s. There was this huge disparity between those who had and those who don't. Okay? It's actually worse today than it was then. Okay? And the middle class, in my opinion, has to learn how to, while living a reasonable life for themselves, however you define that individually, they have to figure out how to keep their capital intact. That's what we do with the irrevocable trust, is help keep it intact. Is it going to work as well as I would like every time? Of course not. Okay? But we create the opportunity for your children to do better than they would otherwise. I'd like to think that we also create opportunities for grandchildren to do a lot better. See, there's this notion that somehow that our problem as middle-class people in the jobs we've lost is a product of international trade and not being dealt with properly. I can't use the terms I would with people that I know well about my opinion of that statement, but it is every bit of that. It's because of technological change. And that impact is going to continue to grow, and the only ones of our children and grandchildren who are going to fare well are those whose families have been positioned to be able to help them get the education that they need to participate in whatever this new economy is going to be. And the problem is, my granddaughter's first month of preschool cost 4 times, almost 4 times what my first semester of college cost. And these costs are only getting worse. That if you look at what inflation has done to our cost of living, because I can go on for too long at this. Bottom line, what the average wage earner makes today, adjusted for inflation, is less than what I was making in 1967. Well, actually, I was doing better than average even then, okay? The average wage earner today makes less than they did in 1967, significantly less. Household incomes are up because married couples, almost in all cases, both of them work. Okay? We have tons of people who are living together, and they're living together because by having two incomes, okay, they're able to maintain a reasonable standard of living. The stuff we do makes a huge difference. And no less an authority than the U.S. Supreme Court has said that if you don't use the rules that are there for income tax planning to minimize your tax, then it's foolish. And so is it unethical? No, I think it is unreasonable, and perhaps if one of your obligations in life is to do the best you can by your family honestly, then it is unethical to not do this kind of work and planning. Oh, and by the way, I have no strong feelings about this subject. Okay? So was that enough of an answer to help you?
What was I here to talk about? Irrevocable trust.
Irrevocable trust. We'll go through some examples of how we could actually use those. Okay? Here's a situation. We got Steve and Sue. They're worth about $600,000 net worth. They got a home. They got some stocks. They got an IRA. They got cash and money in the bank. Okay? So that's where we're starting. Now, if care is needed, okay? So if one of them needs care, the other's at home, they got a $600,000 estate, and they've done no pre-planning. Okay? Then it would be possible, given their facts. Oh, by the way, I got to choose the facts here, okay? We could protect about $322,000. Okay? We got the Medicaid applicant gets to keep $1,600. We got the community spouse resource allowance of $120. The home's exempt, $200. Okay? So $322, $277 is a risk, and that's what we see people doing all the time. See, you can't do this stuff without using the rules. It's just a question of, do you use all the rules or just some of them? Okay? Now, we take a look here. We've got just one of them. They can have $1,600. If both of them need care, we can only have $2,400. So everything's got to go if both of them need care. Okay? We end up with $1,600 and $2,400. So essentially, you're standing in a position of losing all of it. If we use irrevocable trust, which we started to talk about, and we take advantage of some of this pre-planning that we showed you with the Richards earlier, okay? We've got a home, we can put that in trust. We've got investment accounts, we can put that in the trust. Cash in the bank, we put $100,000. Do you always put everything in there? No, you have to set it out, figure out what's right for you, where you are, okay? Because when we put it in the trust, things change. Okay, and I can't cover all of how this works, but sometimes it doesn't make sense to put it in trust. It's an individual decision. You have to understand the what, the where, the why, the how. Now, IRAs, we don't put into trust, and the reason we don't put them into trust is because generally it doesn't make sense to pay a big chunk of income tax to be able to move it to a trust. That's a really big cost. Okay? You notice we're saying, I said 100, maybe 50. It might be you put in 50 and live on 100. Okay? So it's a very much individualized choice. Okay? And what we know is if we get this done this way in advance, 5 years in advance, we're going to win. So we put all the house, put in all that stuff in the trust. We got 450,000 in there. We got 1,600 for the applicant. Maximum we spend down to qualify for Medicaid is about 27.5. So we're not skating totally on paying something for care. Okay. We got, the year I did this, the CSR was 119, now 123. Numbers have changed a little bit. So we end up protecting 570,000 out of a total of 600. Does that sound like a pretty good deal? So here we've got a single survivor. We've got single Medicaid, 450 in trust. We got 1,600. Okay. Total protected 451. We got 148,000 at risk. If they both apply for Medicaid, we only have 147,000 at risk. So what we're able, by using the trust and doing it early, we minimize the amount of our capital that's going to be lost. Okay? Yes.
What would be the reason to not put everything in an irrevocable trust?
Because if you can do whatever you want with it, if you can put it in your hot little hands and go to Foxwoods or pay groceries with it, then we didn't gain anything. That's a revocable trust. Irrevocable trust, we're going to have to restrict what you can do with what's there. And that's why I'm showing you numbers that don't necessarily represent exactly what we would do for anybody. Okay?
And you pay taxes on the trust?
No.
No?
Oh yeah, you heard that. Somebody told you if you've got an irrevocable trust, you've got to pay a lot of income taxes.
Right.
Right? Wrong.
Wrong. Okay.
Got it?
That's
But that's true. That's true, but it can be wrong. Remember, I have a special license. Okay? See, here's the thing. The problem is that people hear something, and this includes attorneys, okay? And they say, well, this is the way it's got to be. Okay? Well, oftentimes that's just not true. Okay? The rules, what's the most complicated thing that you do in your practice with somebody? What's the most difficult thing to do?
Filling out bill insurance.
Filling out applications? I was thinking maybe it was trying to get families to get along. Okay? Or maybe those of you who work in rehab is getting somebody actually finish rehab and come out on the other side okay. Okay? Now, there are a lot of books written about the process, okay? But when the rubber meets the road, there's a whole lot of things that are not what's in the book. Okay? I'm not pretending that we created a new book, okay? But we're willing to think about things differently and use existing rules, okay? Because most of the irrevocable trusts we do, the tax is going to be paid by the trust maker, and is going to be paid at the trust maker's rates. There's a whole lot of education that has to be done, however, to get people's heads around it so that they understand it and it makes sense. Okay? Because the simplest thing to do is just give it to the kids and hope they take care of you and nothing bad happens. Okay? I find most people would rather have more control than that. And they'd like to have more certainty that if we're going to go this trouble, that it works. Okay? So here's our comparison. And I wasn't going to take questions until the end. You are tricky. Okay? So here's an example. With no pre-planning, at best we've got 279 at risk. That's our best outcome. with trust, we got 29,000. So, which rules do you want to use? The ones that benefit you the most, or the ones that benefit the system most? Oh, I don't know. Okay? See, I guess part of my thought is if you don't use the rules that the system has created, then the system is using you, and you're volunteering for it. No pre-planning with front, okay, where we have both having problems, we end up with, say, we're better off to the tune of $400,000. Worst case, you're better off to the tune of $400,000. Okay? Now, in the book that some of you received, Don't Go Broke in the Nursing Home, this is a scenario pulled out from there. Okay? Because I wanted you to try and understand some of these asset-based long-term care policies a little bit better. Okay? This is Patty. She's 63. Never wants to go to a nursing home. That's like everybody, right? Okay? So she's got $250,000 in an IRA, $370 in the CD, $300 in stocks and bonds. So she's doing pretty good. Okay? Is Patty wealthy?
To me?
She's doing pretty well, but she is not wealthy. Okay? But she's also not a social worker. She can take and transfer the IRA into an arrangement that is a partially tax-free long-term care arrangement that will furnish $480,000 partially tax-free, or will furnish that much in the way of death benefit. And by the way, she can say, I changed my mind, I want my money all back. Okay? So it's heads I win, tails I break even, and I maybe even come ahead in other ways. She would get a $9,600 a month benefit that is partially tax-free, can be paid for home health care, assisted living, skilled care. So this is one way of dealing with that problem. Okay? There's more explanation in the book if you want to know more about it, because I only got a couple of slides here. Okay? We use irrevocable trust because if we set them up while you're well, while you got your wits about you, you're not being unduly influenced by somebody, we can create structures that help protect from getting scammed. The undue influence, we can protect everything from creditors, lawsuits. We can create arrangements so that what you pass on to your beneficiaries, that what you leave them is protected from their problems, whether it's substance abuse or bad financial judgment, from marriages that don't work out. Need to know if those are, those things are important to you to protect from. I think they are because, what's the divorce rate in this country? Huh? 1 in 2. So it's about 50-50. Bankruptcy, the biggest source of bankruptcy still is people who have medical bills they can't pay. And I don't think it's because of cosmetic surgery. Okay? It's a thought. I don't know. Yeah. We typically create irrevocable trusts that are not complete for gift tax purposes. So we transfer assets in, and they're not a complete gift. So you can, while you transfer it away from yourself, and we've arranged it typically so it's protected from any bad things that happen to you, as well as your other loved ones that are ultimate beneficiaries, there's no completed gift until really, after you die, it's no longer a gift, it's a post-death wealth transfer. And you get to control who gets what, you know, and when, and you can retain a lot of power. So irrevocable, on one hand, you can't change it very much, but the biggest thing I find people want to change is who gets what, how, and when. Well, we keep that right, okay? Income? Well, you can keep income. I usually try and come up with arrangements where you think you can be comfortable without keeping the income, because it makes the administration simpler, less likely to mess it up. We can make sure it's not going to be taken away from your beneficiaries, whether that's, again, a spouse or children, grandchildren. Trusts are much more flexible, more user-friendly than what most people grew up with. To the extent they had any exposures to trust, we rarely use professional trustees, mostly as family members that are trustees, and we try and do some training to help them understand what they're involved in, you know, what the roles are. The irrevocable burial reserve, that's an irrevocable trust. Okay? And that's part of making sure we can pay for the funeral. Okay? Like I said, we put about $8,000 into that. You can pay for other costs on top of that. Now, if somebody wanted to talk about supplemental needs, okay? Supplemental needs trusts are almost always irrevocable trusts. Okay? And they are also called special needs trusts. They actually come in about two principal flavors. You've got the first party special needs trust, and that is where the disabled individual uses their own money to create the trust. And so this is where, this will sound like I'm telling you something that's contrary to what I said earlier. You can actually create this trust with your own money, and you can protect it from your creditors. And the problem is that whatever is left in the trust that you're passing has to go to repay the state for any benefits that you received under any of the various programs you might have been getting help with. So it's not a great way of perpetuating wealth for your children or others. Okay? It says court approval required, is continued court supervision, so the regular accountings and whatever that has to be done with the probate court, which is one of the issues that come with testamentary trust as well. That's a trust created under a will. This is not under a will. You create it during your lifetime. The law used to require that a parent or guardian be the one who set it up using your money. But Congress finally got convinced it really, if we're using an individual's money and they're not incompetent, there's no reason that we have to have a guardian or a conservator involved to do this. And these are frequently, any number of times we've done these for folks because grandma or grandpa or aunt or uncle or somebody left an individual a chunk of money, and when they did their planning, the individual was fine, and now they have a problem. Okay? They need help paying medical bills. That's really the big one, don't pay medical bills. And the choice is either become disqualified and ultimately spend everything, or take that money, put it, create this trust, submit to the court supervision and all the accountings and whatever, and keep your benefit. Which one would you do? It was my problem. I create the trust, right? So that's first party in a nutshell. Now, these we're not spending any time on administering these trusts and talking about it. Anytime that we're trying to deal with special needs or supplemental needs trusts, the administration becomes really, really important, because if the beneficiary is receiving SSI, supplemental security income, it's pretty easy to mess the trust up. Okay? If it's Social Security disability income, less of a problem. So that you got to understand income sources and whatever, and depending on what you're doing, we may want to get a professional trustee. We virtually never, I can't remember ever creating one of these where the grantor, the trust maker, was the trustee. I think that's inappropriate, okay? Because we've given them too much control. So we have to have an independent third party be a trustee. I shouldn't say independent. We have to have somebody other than the grantor be the trustee of this, okay? And they can be messed up, okay? And if you mess them up, you can't necessarily fix it, okay? Sometimes you can't. Third party. A third party supplemental needs trust is a irrevocable trust created by somebody other than the beneficiary. It can be a parent, it can be a grandparent, it can be a friend, okay? Yeah, so the funds come from someone else other than the beneficiary. I started reading that, I thought it said for a minute when I looked at it, you can use the funds for anybody but a disabled person. I said, no, that's totally backwards. That's not what it says, okay? So we're using parents, other family members. It may be you're funding these at somebody's death. You know, there is part of their estate plan and as money pours in, sometimes they're funded incrementally over time. Sometimes there's life insurance put in these. There's a lot of different ways. But if it's a third-party trust, there's no payback required. Okay? Whoever created the trust can control it. What happens at the death of the disabled individual? Okay. Now, that sounds pretty simple, right? You put the money in there. You don't spend it on anything that would otherwise be paid for by the state. So what you're trying to do is supplement the benefits they might otherwise be available to. Okay. You may want to provide for who's going to, because if you're setting this up for somebody, they have some significant health issues. They may be serious functional issues, cognitive or physical. You may want to be sure, you may want to use this as a means of creating the setup for how they're going to be assisted in dealing with those problems over the remainder of their lifetime, how you're going to choose and find those people and what you're going to pay for or not. We've reviewed a number of these, and rarely do we see these kind of really important issues addressed. Because it's not just about the money. It's about how we're taking care of this individual. What do we need to do? Okay? So, as I said, there are two ways to create it. And don't you like inter vivos, inter vivos? Isn't that a nice big word? Okay? How about lifetime? Okay? All that means is you created it during your lifetime. Okay? Okay. Testamentary, created by will. They can also be funded by revocable, they can become part of a revocable trust, they can be part of an irrevocable trust. Because really what we're trying to do is figure out how to take care of a beneficiary with whatever's going to them. Okay? I can't remember what FP is supposed to stand for. Some others. I think I'm getting tired, folks. So that's, you can create them either way. And I said I threw in revocable and irrevocable, because you can create an irrevocable trust as part of your Medicaid plan that also funds a supplemental needs trust for one of your beneficiaries. Or you may want to have provisions that say, right now, everybody's fine, but boy, if something happens to one of them, or more of them, I want what's left to them protected from this. And so, there's a lot of different ways we can get there, but these are the two principal ways we see it done. Yeah? We've got federal law. So we've got federal statutes that says, here's the requirements that we have to have. And in fact, the federal statutes are enhanced by the Social Security POMS, Policy Operation Manual Statement, so I can't, honestly, God, I've used this abbreviation so long, I can't remember what it stands for. POMS, Social Security POMS, which are the regulations written to interpret the statute, to say what these things are. It is important that you stay on top of this. For instance, one of the things we commonly did at one point with the Supplemental Needs Trust is we would allow the trust to pay for the travel of family to come see the individual or go with them somewhere. And a change in the POMS is probably 7, 8 years ago was, no, that's not for the exclusive benefit of the individual, because that's another one of the requirements. Yeah, not for that benefit, it doesn't exclusively benefit that individual. But if you have limited mobility and limited funds, personally, if you want to see family, which I think is a good thing, you're only doing it for that individual's benefit. The fact that somebody else has an ancillary benefit is beside the point. But that's how it was for a long, long time, and now it's not. So they end up always being irrevocable. If they start out revocable, then it is because we are funding them over time and we have somebody else as a beneficiary. Okay? We have to have very clearly spelled out distribution standards so that whoever is trustee knows that they can't just distribute the money however, whenever they want. Okay? You do have to follow the rules. Now, once you get your head around them, you know, these work very well, but this is not the same as just having a piggy bank that you take money out of and spend on that individual. Okay? It's also not a piggy bank that you take the money and spend it on yourself. One of the first special needs trusts I dealt with, the parents decided they should buy themselves a house. They were trustees. It was still owned by the trust, but the son that the trust was set up for didn't live in the trust, didn't live in the house.